Hi, I'm Waco criminal defense attorney Walter Reeves, and today I want to talk with you about what you need to worry about if you're out on bond. If you're lucky enough to be released from jail on a bond, you don't need to just worry about your case. You also need to worry about your bond and making sure you stay out of jail. And the purpose of this video is to explain a few of the things you need to know and pay attention to. The first is pretty obvious. You need to keep your bondsman happy. That includes at least two things. The first is to make sure that they're paid if you still owe them money. And the second is to check in when they tell you to. Their job is to keep track of you so that they can make sure you show up in court. And so they need to know where you are at all times. So what happens if you don't do what your bondsman says? They can go off your bond, which is called a surety off bond. What that means is that they'll get a warrant from the judge and have you arrested and put back in jail. And you'll then have to try to bond out again if you don't want to stay there. The second thing you need to know is what your conditions of bond are and make sure that you follow them. This can vary on both the court and the type of case. Generally, in most misdemeanors, there aren't going to be any bond conditions. The exception, however, are DWI cases and assault cases. For example, in some DWI cases, a condition of bond may be that you install an interlock in your car, which is something that you have to blow into before you can start it. There also may be a condition that you not drink. And it's important to know that, because if you have an interlock, it will only lock you out if you're over the legal limit. But it'll also register any amount of alcohol, and that gets reported. So there's evidence you're in violation of your bond condition, even though you might think everything is all right. In assault cases, especially anything involving family violence, there are going to be conditions that you have no contact with the victim. There will also be conditions limiting how close to the victim you can go, which limits where you can go. You need to make sure you know that, because it usually involves not only where they work, but it can also involve and include other family members. What else do you need to worry about? There's a condition placed by some courts that require you to submit to drug testing. Usually those tests are done at court appearances. Even if you test positive, your bond can be revoked, and you're either going to have to stay in jail or post another bond, usually in a higher amount. And it should also go without saying, but I'll go ahead and say it. You need to stay out of trouble while you're on bond. If you get arrested again on a new charge, you may bond out on that case only to find yourself looking at the possibility of going back to jail on the first one. A couple of things can happen. A judge can revoke your bond based on the new arrest, or they can raise it, which will require you to post another bond. If you're on felony bond and get arrested on another felony, chances are that's going to be caught pretty quickly. Most court staffs monitor that, and you may find your original bond revoked before you even make it out on the new charge. In case you haven't figured out, it's important to have a lawyer who knows and understands how this all works. An experienced criminal defense attorney can help in getting conditions waived or suspended in some cases, and can also help in getting bonds reinstated or new bonds set. If you found this video helpful, please share it with your friends or family. And if you or a loved one need help with a criminal matter, please give us a call.